Alright, so this is Decent We the People News one more time. This video is without prejudice and or without recourse. I'm not an attorney, not giving legal advice. Maybe in my opinion, that's it. No more, no less. Do not take it as such. Alright? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary, people. Okay? Now, in my last video, it's the same video. This is part 2. Infant. Alright? Now, the gentleman on this video, I stand arm length from him. So, because if I stand next to him, I feel as if I'm an infant. So, I'm on y'all's side, okay? Alright, because his knowledge is way beyond mine. So, again, me and him stood beside one another. His knowledge is way beyond mine, and I'm going to stand arm length because I feel that I'm an infant to him, right? He can stand on his rights as a man. I'm not into that level. I may or may not have to seek and waive my rights to get an attorney. It just depends on the cases that may come at hand. But what I am doing right now is learning to be able to be in his level and above the attorneys and our officials. I want to be their bosses. I want to get my rightful place back. I no longer want to be a person. I want to be a man and stand as a man, not as a person. Okay? And that's even in legalese, by the way. If you look up legalese, what a person is, remember, y'all, we've been totally dumbed down. Public school started off being forced to actually study the Constitution because they thought it was very important for everybody to know the Constitution. Just over a period of time, they diluted it and steered away from the Constitution because they cannot have their little sheep running free. Right? That's how public schools actually got started, was to actually know. Let me also say this. It was actually unconstitutional what they did on this public school thing. But they figured it was so important about we the people understanding our constitutional rights, right? And I'm using the words loosely for y'all. Okay, because the Constitution does not give us rights. We stand on the Constitution for our inalienable rights that they're trespassing upon our rights. The Constitution is for them not to trespass upon us. Alright, so I figure I better let you guys know that, I'm just not picking on y'all or anything like that. With the knowledge this man has, if I stand beside him, I'm going to stay arm length because I feel like I'm an infant with him. Alright, let's see, proceed forward.
Evidence with the court pleadings and thereby refusal to accept a docket pleading is consistent with obstruction of evidence and obstruction with due process of law. Now, that's pretty serious. Obstruction of due process of law is, in fact, ladies and gentlemen, obstruction of justice, which means the liability now shifts onto her for being derelict in her duty, and it's oppression under color of authority because she thinks she has the right to alter this man's said claim, and in fact she does not. Okay? Now, again, we're not trying to be malicious or assholes about this, just trying to help them out, and my commentary is meant to be funny. I really am not trying to ostracize her or make her feel as though she's unworthy of her pay or unjustly enriching herself under false pretenses that she actually knows her job, okay? Thereby, this clerk's office and its employees' refusal to accept and docket court pleadings will be involved in violating the secured rights and privileges of the undersigned. Now, first of all, if the undersigned has privileges, he is in the wrong venue. The privileges only extend to corporations, entities, ens legis persons, things of that nature. As a man, we have secured unalienable rights, and our rights to redress a grievance, remove controversy, and provide remedy are our unalienable rights as a man to press our claim before a competent court of competent jurisdiction, all while filing due process of law, which does not include federal rules of civil procedure. But we'll get to that in just a moment. Hang tight. Of the undersigned. And this document will serve as proof in the future proceedings for damages that this clerk's office was given the opportunity to correct its action but refused to accept and file the paperwork brought by the undersigned. Okay, let me explain this to you. They didn't necessarily refuse. By the time we left, they did do their job. The problem is the deputy clerk of the court altered it. And you see this little thing up here that says CV? That stands for civil, and it really should say MS or MC, miscellaneous, okay, because we are not in their jurisdiction. And we made it perfectly clear that we are not in the jurisdiction of the United States, its territories, its subsidiary corporations, or its municipalities. You are grossly making an error at law, which is obstruction of justice. And we advised them to please refrain from making legal determinations. If there is such a legal determination that needs to be made, it will be made before a competent member of the court. Period. Not a assistant clerk of the court. Let's go on further. For damages, that this clerk's office was given the opportunity to correct its actions but refused to accept and file the paperwork brought by the undersigned. Even though they filed it, they altered it. And that in itself is an issue. They are not qualified to make those kind of legal determinations. And again, that decision should have been made before a competent member of the judiciary, before a judicial officer. Under full faith and credit clause of Article 4, Section 1, of the U.S. Constitution, this court must honor judgments by courts within the territories of the United States of America, especially the highest court of the land, the Supreme Court of the United States. Number 5, the clerk's office must accept possession and file pleadings regardless of local rules and thereby cannot refuse to accept possession under the claim of local rules. When you were telling me that I have to comply with the federal rules of civil procedure, all while absconding from showing me how the federal rules of civil procedures apply to I as a man, not as an employee of the government, which I have never been employed by the government, you were derelict in your duty and making legal determinations. Now, you proclaim to be a lawyer. I've since called the Indiana State Bar. They have not provided me a bar card yet. I have gotten online to see if you are a bar card carrying member, part of the legal society. I have yet to see any evidence of that. I would love to see the fact that you are a bar card carrying member. It would please me greatly to know that I wasn't that you weren't trying to give legal advice without being a bar card carrying member, which means that would have been the unauthorized practice of law. Not that I need legal advice, because I really don't need legal advice, okay? Legal is the undoing of God's law, where I would much rather be in the lawful side of things. God's law, natural law. The standard for the clerk's office to accept possession and file pleadings can be found under the United States versus Lombardo, 241 U.S. 73, 76, 77, 36, SCT 508, 60, LED 897, 1916. Number 6. The provisions of the Federal Rules of Civil Procedures concerning filing supplements follow the Lombardo approach. The provisions of the Federal Rules of Civil Procedures concerning filing supplement rather than alter the Lombardo approach. The clerk shall not refuse to accept for filing any paper presented for the purpose solely because it is not presented in proper form as required by these rules of any local rules or practices. Stone Street Capital Inc. versus McDonald's Corp. 300 F Superior 2D 345 District Court, D. Maryland. The clerk of the court, like a recorder, is required to accept pleadings and then file them. Period. Not make legal determinations about the way they're structured. The Federal Rules of Civil Procedure was the agreed upon format for the court proceedings. A paper is filed upon delivering it, and the clerk accepting delivery. Federal Rules, FPRC 5D2. The job of the clerk of the court is to file pleadings and other documents, maintain the court's files, and inform litigants of the entry of the court orders. Saunders versus Department of Corrections, 815F Superior Court, 1148, H49 ND 3, 1993, Williams versus Panonsky. The duty of the clerk is to make his record correctly, represent the proceedings in the case. Wetmore versus Carrick. Failing to file documents presented and reflected the documents on the docket is a failure to perform the ministerial duties of the clerk of the court. It doesn't say to alter them to your liking. It says failing to file documents presented and reflected the documents on the docket is failure to perform the ministerial duties of the clerk of the court. Indiana Constitution states in Article 1, Section 12, and I had to read this to them, so far be it from me to explain the law to anybody, but I don't have a problem reading out loud. Bill of Rights. Section 12, courts open, remedy by due course of law, administration of justice, all courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. This was amended November 6, 1984. Attempting to charge a fee in the interest of justice to remove controversy to provide remedy is extortion and or barratry. I require the law to be produced for the following: the finding of facts and the conclusion of law, if you believe the answer is yes to any of the following. Is there a law that states there is nowhere in the United States of America for a man or a woman not fluent in legalese or a member of your society to move a claim or invoke their right to a trial by jury? Number 2. Is there a law that states a man or woman have to belong to or hire a member of the legal society to move a claim? Number 3. Is there a law that states that the man or woman provides justification and or excuse for the robbery or theft of another man's property, that said robber, man or woman, is not required to remedy in the spoken form in open court what moves them to remove said property or hire a lawyer to explain this on their behalf? Number 4. Is there a law that states that the court clerk does not have to provide their oath of office or bond, and that they have the right to determine law or deny man's or woman's claim, and that any man has the right to process their claim via public venue for the use of any man or woman requiring justice and the immediate release of their property? Number 5. Do the federal rules of civil procedure apply to I, a man, Derek? Number 6. What is the difference between lawful and legal? Number 7. Does the clerk of the court have the power to alter the property of I, in this instance, the claim of Wilder? Now, it's obviously not my claim. However, I was there to witness it, so these are the series of questions that she got served. Now, we will see what she does with it. Why is this not opening all the way? Okay, so Federal Rules of Civil Procedure, Rule 17 says the capacity of the plaintiff and defendant is public officer. All right, so Federal Rules of Civil Procedure apply to who? Well, Rule 17 in the Federal Rules of Civil Procedure says that it applies to public officers. It's a reflection of Article 1, Section 8, Clause 14, and Article 3, Section 2 and 3. Recognize that those are the only two articles for the type of courts they have in their jurisdiction. Now, we're not operating in their jurisdiction, and we thank you very much, Malika, for helping us out in this instance with that great bit of knowledge that you have provided under the circumstances, and we thank you very much. So with that said, ladies and gentlemen, don't take flack from anybody. Be accountable, be responsible, be polite, be dignified, and you can get this stuff done too. Now, we have the docket numbers. We'll just merely amend them because she trespassed on the claim. We want to offer her forgiveness for her ignorance and operating in haste. There's an old maxim of law that says, he who pays with haste pays twice. All right. So instead of making a hasty legal determination, you probably should have walked upstairs and said, Your Honor, I need to talk to you real quick. There's a peculiar man down there that he seems to think he knows something, and he's telling me that I can't alter this man's claim. Is there any merit to that? Well, what's the man say? He says he would like it filed miscellaneously, not civilly or criminally, because that falls within the territorial jurisdiction of the United States, and he's clearly operating in the Republic. Yeah, give that man what he wants. You see, but instead, you operated with haste, wanting to be right, having be rightitis. You stamped this civil, which altered this man's claim, and tried to bring it back into the jurisdiction of the United States, Title 28, 300215A, and its subsidiary corporations, and that is not what the intent of this man's claim is, period. So with that said, I love you guys. Anybody do the math on that? Five times 400, and I think it's 402 or $420. Pretty good chunk of change that we saved today, just knowing the law of the land. And with that said, for you students, participating members who took the class, it is 12 hours, 54 minutes, and 13 seconds long. It is finally uploaded to Mega. I'm just sitting here putting the rest of it in there. You guys will have it this evening, okay?
All right. So, if you want to watch some more videos of his, all right, where the storm clouds are gathering, okay? Anyway, like I said before, this is arm length because I have no knowledge. I'm not in his level, okay? This way the people knows. It's just a learning video, y'all. To think outside the box. Think as a man or woman, and not as a person. And not as an infant. Till next time. Bye, y'all.